Salary has been withheld, my lords, for the past 19 months, my lords. I'm seeking mandamus to release my salaries, my lords.
ಯಾರು ಕೊಡ್ಬೇಕಾಗಿರೋದು?
Respond number 2, my lords.
Yes, madam.
As the order has been passed by this honorable court, it was subject to result of the writ petition and the.
ಎಲ್ಲಿದೆ?
My lords, may I
What's
please?
the matter?
My lords, my appointment, my lords, in 2023 was done by respond number 2, my lords, with following all the procedure. My lords, in 2024, my lords, the respond number 2 passes an order, my lords, by withholding the salaries, my lords. That is challenged by me, and the interim order is granted by coordinate bench of this honorable court, my lords. My lords, later on, respond number 2 issues show cause notice, my lords, for cancellation of my appointment.
That is stayed.
That is also stayed. When
Now,
that
there are
order
two
is
writ petitions pending, is it?
yes, my 3 writ petition.
Idella
When
ide.
that was, my lords, when show cause notice itself was stayed, my lords, the respond number 2 passes cancellation of my appointment, my lords. That is stayed by my lords. Whatever orders were passed by respond number 2 are stayed by this honorable court, my lords. Despite of that, they are not releasing my salaries.
You are working?
Yes, my lords.
You continue to work?
This is the must rule, my lords. And even I've given representations, my lords, to them. Then respond number 2 states that there is no specific order by this honorable court to release of my salary, hence I cannot release the salaries, is what the respond number 2 states.
ಬರ್ತ್ ಕೊಟ್ಟಿದಾರ ಹೇಳಿದ್ರ?
ಹೇಳಿದ್ದಾರೆ, my lords.
As your lordship of this, because of this honorable court's order, your lordship, we have held up, your lordship, because
You have continued.
It is violative of Article 23, 21 and 300 A,
Good.
my
I
lords.
expected that.
direction, because of this honorable court's order only, we have followed that order, your lordship.
Right. ಅಷ್ಟೇ ಅಲ್ಲ? ನೀವು ಯಾರು?
So I appear for respond number 5 minutes.
Formal party.
Headmaster of the school minutes.
Headmaster. The petitioner is before this court seeking the following prayer. Facts in brief, germane, are as follows. Permission is granted by the second respondent to fill up all vacant posts in the fifth respondent institution. The petitioner thus comes to be appointed as an assistant teacher in the fifth respondent school. The salary of the petitioner is said to have been fixed on the petitioner thus continued to work without any break. An act of withholding of salary comes about without any rhyme or reason. Therefore, the petitioner approaches this court. An interim order is passed staying the order of withholding of salary. After the passage of the said order, the second respondent is said to have issued a show cause notice to the petitioner seeking to show cause as to why the appointment should not be cancelled. And the show cause notice is again challenged before this court in writ petition. And there is an interim order of stay of the show cause notice and all further proceedings taken thereto or to be taken thereto. The second respondent again passes an order of cancellation of appointment of the petitioner on 12/9/2024, and a direction was issued to relieve the petitioner from services. Aggrieved by the said order, the petitioner prefers an appeal under section 131 of the Education Act before the appellate authority. The appellate authority sets the order aside and remits the matter back to the hands of the second respondent for a fresh consideration. The second respondent now confirms the cancellation of appointment, which is challenged in writ petition, and an interim order of status quo, the appointment is granted. Therefore, the present writ petition is the fourth in line, as 3 writ petitions are preferred by the petitioner being aggrieved by repeated acts of the management repeated acts of the second respondent in either cancelling the appointment or not withholding salary. The petitioner is now before this court seeking the aforequoted prayer of release of salary which has not been paid since May 2024 till today. The learned counsel taking this court through the documents appended to the petition would seek to demonstrate that the petitioner has been working either on the appointment of the fifth respondent or on the interim order so granted by this court in 3 of the writ petitions. Nonetheless, he has been working throughout from May 2024 till today. She has placed on record the muster roll of marking of attendance on every day of working from May 2024 till today. The representations are also submitted to the the learned counsel submits representations are also submitted to the respondent for release of salary. The second respondent has not released salary, therefore the petitioner for the fourth time is at the doors of this court. The learned HCGP, though would seek to defend the action of issuance of the impugned orders time and again, would contend that those who be defended in the other cases that are pending. The petitioner, but is not in a position to dispute the contention that no salary is paid from May 2024 till today. The defense is that the writ petitions are pending, therefore the salary is not paid. The petitioner working in the institution, in the fifth respondent institution, and the attendance is not in dispute. The aforesaid facts, if the aforesaid dates link in the chain of events are noticed, what would unmistakably emerge is that the petitioner, who has been working since May 2024, since 2023, has not been paid salary from May 2024 till today, which is close to 19 months. Therefore, the petitioner is made to work in the fifth respondent institution without payment of salary. The salary has to be paid by the state is not in dispute. Therefore, the petitioner, assistant teacher, is made to work without salary, which would amount to begar, as obtaining under, which is violative of Article 23 of the Constitution of India. The defense of the state is the pendency of the writ petitions is, to say the least, is preposterous. Any teacher, employee, or otherwise cannot be made to work without payment of salary. As observed here and above, it would amount to begar. In the light of the admitted position that the petitioner is working,
Four petitioners, my lords.
the petitioners are working. The petitioners are working for the last, are working in the fifth respondent institution and have not been paid salary since May 2024. The petition deserves to succeed, but not success simpliciter.
Lordship, because of the writ petitions are pending, Your Lordship, as
So
we
not
have stated
success
in.
simpliciter, as the petitioners shall be paid released salary.
4 weeks, Your Lordship.
The petitioner shall be released salary on or before of December 2025.
Please, Your Lordship.
Since the petitioner is driven to this court time and again by the acts of the second respondent, which is in which the illegality is projected, the cost of litigation of this subject petition in the least should be granted, as it is complaining non-payment of salary. Therefore, for the aforesaid reasons, the following word. The petition is allowed. Cost of rupees, cost of rupees 10,000.
Because, Your Lordship, because of the writ petitions are pending.
Cost of rupees 10,000 to be paid to each of these petitioners. In the event, the salary, a mandamus issues for release of salary of these petitioners within December 2025. In the event the salary is not released on or before December 2025, the cost that is indicated here and above would stand increased to 25,000 rupees to each of these petitioners.
And if not paid on 4/12. Because, Your Lordship, we cannot go beyond the orders of this honorable court also, Your Lordship, as
Madam?
granted.
Salary ಕೊಡಬೇಡಿ ಅಂತಿದೆಯಾ?
ಕೊಡಬೇಡಿ ಅಂತಲ್ಲ, because when management itself
Madam,
is
it is
in
simple.
question.
No court in the country can pass an order. You extract work, don't pay salary. Then the court's direction will become unconstitutional. So
Management itself is in question, then.
it's a different thing. We are working.
That is also state.
Huh?
That is also state, my lords. Everything is state.
Please, Your Lordship,
ಯಾವ್ದು
we
petition
are
numbers
not
ಕೊಡಿ ಅಲ್ಲ?
disputing.
Yes, my lords.
It's pending before me.
No, my lords. that
Pending in
is
writ appeal, my
Writ
lords.
appeal.
ಓ ಅದು ಡಿಸ್ಪೋಸ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ. That is the reason, your lordship. We have stated in the writ petition
Any,
dispose ಆಗಿದೆ.
madam, ಏನ್ ಬೇಕಾದ್ರೆ ಇರ್ಬೋದು, unless there is a positive order by the court, don't pay salary. You are bound to pay salary.
I oblige your lordship, but the reason why we have not paid, the writ petition is allowed
No.
and
Whose bulletproof head is this that doesn't get these things into? Second respondent, yeah, will summon him? Commissioner,
please, your lordship.
doesn't he know the law?
Writ petition is allowed, your lordship. That is the reason.
Which ನಿಮ್ petition ನ?
Our
ಅವ್ರ
petition.
ಪರವಾಗಿ ತಾನೇ ಅಲೋ ಆಗಿರೋದು. ಯಾವ್ದಾದ್ರು ಆರ್ಡರ್ ನಿಮ್ ಅಗೇನ್ಸ್ಟ್ ಆಗಿದೆಯಾ?
No, my lords.
ಮತ್ತೆ ಅದಕ್ಕೆ ಹೇಳಿದ್ದು, which bulletproof head is that? That is Article 23 is not getting into his head.
Against management, your lordship, it was.
My lords.
Against management ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದಾರೋ ಇಲ್ವೋ ಈಗ?
Insofar as cost is, mandamus, I am not disputing, your lordship, insofar as cost is concerned.
ಅದ್ ಬೇಕಾದ್ರೆ ಹೇಳ್ತೀನಿ, despite vehement opposition of the learned HCGP not to impose costs, I deem it appropriate to impose costs. ಸ್ಯಾಲ್ರಿ ಇದೆ ಹೆಂಗ್ ಮೇಡಮ್ ಕೆಲಸ ಮಾಡಿಸ್ತೀವಿ? ಟೀಚರ್ಸ್ ತೊಂದರೆ ಸುಮ್ಮನೆ ಇರೋದೇ ಇಲ್ಲ. ನೀವು ನೋಡ್ತಾನೆ ಇದ್ದೀರಾ, ಪೆನ್ಷನ್ ಕೊಟ್ಟಿಲ್ಲ, ಸ್ಯಾಲ್ರಿ ಕೊಟ್ಟಿಲ್ಲ ಫಾರ್ ಅ ಟೀಚರ್ ಅಂದ್ರೆ ವಿಲ್ ನಾಟ್ ಕೀಪ್ ಕ್ವೈಟ್. ಟೀಚರ್ಗೆ ಬೇರೆ ಗವರ್ಮೆಂಟ್ ಸರ್ವೆಂಟ್ ತರ ಬೇರೆ ಇದಿರಲ್ಲ, ಸಂಬಳ
ಇನ್ನು 2
ಮಾತ್ರ.
weeks ಅಂತ ಹೇಳ್ರಿ, I will convey, your lordship. Within 2 weeks, I will communicate.
No.
Cost
My lords, the
where-
problem is
ಅದ್ರ
one
ಮೇಲೆ
of,
appeal ಆಗ್ತದೆ.
Alla, my lords, the problem is one of the petitioner's marriage was fixed, my lords. Due to withholding of the salary, the marriage is also.
2 weeks.
The host of-
ಕಾಸ್ಟ್ ಅವ್ರಿಗೆ ಮಾತ್ರ ಕೊಡೋಣ ಕೊಡಿ.
2 weeks ಅಂತಾನೆ ಹೇಳಿ, at least.
4th of December. In the event it is not released,
Please,
ಅವಾಗ the event it is not released, the petitioners become entitled to 25,000 rupees cost
please, your lordship,
each.
please.
Highly obliged.
It's good. ಈ ತರ ಸಿನಾಪ್ಸಿಸ್ ಕೊಟ್ಟರೆ we'll finish it off fast.